Hello and welcome to this presentation on ADR and mediation as provided by the Dispute Settlement Centre Victoria. This is part of a series of law talks with Victorian Law Foundation, and I'd like to start by acknowledging that I'm making this presentation on Aboriginal land. So I pay my respects to traditional custodians on the land on which I'm seated, the Wurundjeri people of the Kulin Nations, and I pay my respects to their leaders past, present and emerging. So today I'm going to talk about this organisation that's funded by the government. It's part of the Department of Justice and Community Safety, and it's called the Dispute Settlement Centre Victoria. And what are we best known for? We're best known for helping neighbours resolve their fencing disputes. But in fact, we do a lot more. We're also known in how we resolve those disputes by providing a service called mediation. So in this presentation, I'll talk a little bit about what mediation is, how it's different from other forms of ADR, which are sometimes known as appropriate dispute resolution or alternative dispute resolution. The terms are used interchangeably, and how that fits as part of the legal system. So what else do we do? Well, if you have a look at our website, you'll see that the Dispute Settlement Centre on our front page, our mission, our purpose is to empower and assist the Victorian community to prevent and resolve issues. And that's to ease pressure on the judicial system and to help the community to thrive. And how we do this is providing free dispute resolution services. So we don't just say mediation, because in many cases, to help people resolve disputes, they might not necessarily need to engage in a meeting, a face-to-face meeting to resolve their dispute. There might be other ways to help. So we provide training, and we also provide accreditation for mediators to national standards. Now, before I move to the next slide, it's important we talk about resolving issues. People often talk about resolving conflict. So what are these terms? Disputes, conflict, they're used a bit interchangeably. So let's start with conflict. Conflict can happen for anyone at any time. It's a process that starts in your own mind when your needs aren't being met and another person is getting in the way of that need being met. So this morning, I could be lying in bed and thinking, I don't want to go to work. I've got a conflict. Now, it could simply be that I'm lazy, or it could be something more that there is a conflict with one of my colleagues at work, and that's why I'm not keen to go ahead. Now, if I decide to do nothing about the conflict, I might get up, ignore it, it'll go away. But if I then decide to make a complaint, I might go into work and say to my boss or to the HR department, I don't feel like working at the moment. I'm very stressed because of the behaviour and the treatment that I'm getting from one of my colleagues. Then a process has started. Now, there are many agencies, many services that have complaint resolution. So when a member of the public makes a complaint about a service not being provided, then that service will see if there's a way to find a solution to that so it doesn't enter into a dispute. So what's a dispute? Well, a dispute is when there's a response from the other person who is getting in the way of the person who has the conflict, and they might have their own needs and concerns that are being frustrated as well. So a dispute and a conflict are things that have a bit of a continuum. So conflict starts with one person feeling upset, aggrieved, and conflict could extend all the way to a global, a war. Same with a dispute. Once a dispute process has started, it could just continue on, it could be unresolved, or there could be some intervention. Now, when we use the term complaint, that's a term used in legal process when someone starts a process in the magistrate's court, for example. So disputes can be a legal dispute or it can be a non-legal dispute. And the Dispute Settlement Centre of Victoria, we focus on the non-legal disputes. We're trying to help people resolve these matters before they need to take a legal remedy. So then what is a settlement? Well, we think about the kind of things in the English language we settle. We settle a baby. So a baby's crying, it's upset. So we soothe the baby and we put it to bed. We have a cloud of dust. The dust is agitated, it's flying in the air, and then slowly it settles. And even people, we talk about people coming to a settlement. They arrive at a settlement. They're wandering around in the wilderness and they come down and they settle in a place to stay. So what does that mean when we talk about a dispute? Well, by that we're talking about, literally, we're wanting people to calm down and find a peaceful solution, which is usually something like an agreement, whether that's a written or a verbal agreement. So someone needs to step in and help advise or help the people who are in dispute decide what to do, and they might reach a compromise. Now, see in my illustration that sometimes a settlement might stop the seriousness of the dispute, but people might still be unhappy. There might still be conflict in their own mind. So when people talk about resolution, they're talking about addressing people's resolve, their determination. And they're talking about a resolution. They're trying to find a solution where we can meet both people's needs. So it's a bit deeper than settlement. So even though we call ourselves a dispute settlement centre in Victoria, when it comes to people living next door to each other, we know that a resolution is better than just a settlement. Now, the other part of our name, we're a centre and we're across the state of Victoria. So we have regional offices in the major population centres, Ballarat, Bendigo, Geelong, as well as Melbourne. And we have a panel of mediators located throughout the state. We're also part of the Department of Justice and Community Safety. And when you think about justice, obviously we think about the sandstone buildings, we think about the lawyers, the police, the prisons, the criminal justice system. So the Dispute Settlement Centre sort of aids and supports this service in terms of the civil side of things. So where it's individual who's got a complaint against an individual versus an individual whose behaviour has affected the criminal code of the state and the state needs to take an intervention. So the Dispute Settlement Centre is an opt-in, it's voluntary. So it's a service provided by the Department of Justice and Community Safety in the hope that people will use this as an alternative to the legal process. So what kind of disputes are we talking about? Well, as I said before, we're best known for neighbourhood matters, but also we help clubs and associations, we help community groups, we help shared households, we help families with their intergenerational conflict. We can even help with school disputes, although a lot of disputes in the school community might be resolved by teachers or counsellors. Outside the schoolyard, we often have conflicts that end up in the court between students. So that's where the Dispute Settlement Centre might step in to see if there is a non-legal solution to resolve the conflict. And the commonality with these, all these kind of disputes, as you can see, is they're a relationship. So the main reason why the Dispute Settlement Centre exists and its effectiveness is because there are certain relationships where having a winner and a loser, if you go through a formal court dispute resolving process, you'll end up with one person living next door who's the winner, the other person who's next door is the loser. So the conflict still persists even if the dispute is settled. So we're aiming to provide a better way of resolving the disputes as well as a quicker and more effective way. So there are many other services that are engaged in ADR, and in this cluster here, we have all the services that are involved in family mediation. So separating couples, family law matters, like the family mediation service. There's also a very healthy commercial mediation sector supported by the VicBar, Victoria Law Institute, and not-for-profits like the Resolution Institute. So these are places where people might take their commercial disputes. And finally, we have the government bodies like the Work Cover Authority, the Small Business Commissioner, the Fair Work Ombudsman, who look after and investigate specific kinds of complaints. So when a person comes to the Dispute Settlement Centre with an issue, we would assess if it's suitable for our service or whether there might be another service that's better placed because they have the expertise to resolve those disputes. And many of these services use different forms of ADR depending on the situation, or they might provide a range of services. So the services that work in family dispute resolution offer counselling and offer behaviour management programs, for example, as well as mediation. So where do people find us? Some people find us through their own investigations, through searches, through social media. A large number of people go to these other places where they might take their dispute looking for legal remedy first. So they might go to local government to see if there's a local law around their neighbourhood issue. They might complain to the police or legal aid. They might go to support services like welfare agencies. They might try to get advice from the community legal centre or go straight to the courts. So we're well known to these organisations, and they suggest to people, because it is a voluntary opt-in kind of service, they suggest to people that they try the Dispute Settlement Centre first, because if they can get a resolution through the Dispute Settlement Centre, it will save them time, money and stress. So how do we help people? In fact, the vast majority of people who contact us might not be interested in sitting down with a mediator and talking to the person they've got a conflict with. So a lot of the time, we'll work with people's own conflict resolution skills, their best practice, which we call coaching. So we'll ask them what discussions they've already had, what was the timing, what was the outcome, what were they trying to achieve. So they might have had some legal advice. They might know that there is a legal remedy that they could pursue, but that's going to be expensive and time consuming. So how do they use that bargaining power of a potential court action to negotiate an effective outcome? The second service that we provide is mediation. I'll talk about that in some future slides as well. But mediation is where we organise a meeting between the people who are in dispute, and that meeting is run by a third person, a mediator. And their aim is to help the negotiations between those people to get a satisfactory outcome for both sides. We're also about empowerment. So we provide training and workshop for community leaders, because there are many people who might not want to take their personal dispute to a government agency. They might take this to a community or a faith leader who might do an informal dispute resolution process. So we provide training and workshop for people who are engaged in dispute resolution, so who can help resolve disputes. Well, the most important person is the people who have the dispute themselves. And like it or not, we have conflicts with people every day. When you walk down the street and somebody's walking in the opposite direction, you would negotiate through a series of gestures and eye movements where you're going to walk, where they're going to walk, and you would walk past each other. So the best placed person to resolve a dispute is a person who actually has the need that's not being met. But if they can't resolve that themselves, they may get the support of a loved one. So they might get emotional support, or they might get support from an advice service who would help them write a letter. So if you see in our illustration here of the support person, it's like the coach who's standing behind the lines, providing that support. Or they could get an advocate who's somebody who would argue their case for them. Formally, that could be like a lawyer, or it could be like a union representative. It could be a more articulate relative who stands in front of the person who's in the dispute and puts the arguments forward to the other side. Or you might involve a third person. So you might involve an expert, which often happens in building disputes, where somebody who has expertise specifically in the issue at hand, who can make a recommendation. Often too, we have like ombudsman services that help make recommendations, investigate issues around government service provision, for example. Or you can go through the formal court process. So I've got a picture here of a judge wearing a wig and a gown, but often they don't. They're going through, you can go through tribunals like VCAT, the Magistrates Court, County or Supreme Court. Or finally, you can get a mediator. So a mediator is a third person who also listens to both sides, like a judge, but rather than making a decision or a ruling, a mediator helps both sides understand the other person's point of view so that they can come to an amicable agreement. Now, when I use the word mediator, obviously, you could also use other forms of ADR practitioners. And I should say that people often use a combination of these. So it might well be that they go and they see a lawyer who helps them write a letter and gets the attention of the other person. But then before it goes to a legal process, they might try a mediator first. And if that doesn't work, they might continue through the legal process. So they're not all separate systems. So when I talk about appropriate dispute resolution, and I should say that term is used interchangeably with alternative dispute resolution, we're talking about methods of involving a third person that are not part of the formal legal process. Now, the term appropriate dispute resolution came in because, of course, courts and tribunals do provide mediation as well as part of their case management. So you may well be waiting for your trial and the court may give you the option of electing to go to mediation, either through an externally appointed mediator or somebody appointed by the court. That might be done through consent orders, or it might be part of the civil process. So in the suite of services known as ADR, or appropriate dispute resolution, one part is determinative methods. So that's where the parties have elected to go to a decision maker, an expert, to make a decision. And that's often something that happens in commercial contracts. So it's still considered appropriate dispute resolution or alternative dispute resolution because it's the parties who control the rules of evidence and the rules of how the matter is determined, but the decision is still made by a third party. The other forms of ADR are known as facilitative facilitative ADR because they're helping the parties facilitate their own discussions. So that might be an assisted negotiation through lawyers or advocates. It could be a process of conciliation or mediation. And there's a lot of overlap between conciliation and mediation. Conciliation is often used by government service providers and usually pertaining to specific areas of dispute as determined by legislation. So that might be something around equal opportunity, for example. The same techniques are adopted by a conciliator and a mediator, but a conciliator might use their understanding of the system to give each side an appraisal of how the matter might proceed if they don't reach agreement. So there's a bit more advice there. While a purely facilitative mediation in a service like the Dispute Settlement Centre, our mediators are very careful not to give advice because we want to make sure that if an agreement is reached, the parties feel that they've done so of their own free will and without any coercion by an external person, because we want to make sure that they own the content of the agreement And that increases the likelihood that they will follow through with the agreement because it's basically their bright idea. Now, when people contact the centre, their conflict or their dispute might be a part of continuum escalation. So sometimes if I talk about my workplace, I might wake up in the morning and feel like a bit, I'm not quite sure. I just don't feel it's quite right at work. I might go in and there's my colleague and I say something to my colleague and my colleague says something back and we have a misunderstanding. And then I feel disrespected or offended. So there's tension leading up there. And then later on in the day, we're at a meeting and then we start to say things that are quite destructive about each other in that meeting. And then there's a crisis and our manager brings us into the room and says, your behaviour is affecting the whole team. So when is it appropriate or when should people try mediation? So there's a situation where sometimes it's too soon. There's no point trying to get an external third person in to talk to my problems about my colleague if he or she doesn't even know what those problems are. On the other hand, if we've reached a crisis point, we might be so upset about the situation that neither of us are willing to talk about it with a stranger. So there's kind of a Goldilocks area about when is the best time for a third person, a mediator, to facilitate discussions between, say, neighbours or people in a workplace or people in a club or association. Now, of course, life isn't linear, and what often happens is there are misunderstandings, tensions, crisis, people come down from the crisis, and there's another incident. So the timing of our involvement is crucial to getting a good result. So we have what we call an assessment process. And because we're working with multiple people, we might find, and I won't go through this entire diagram, but just to point out, there's many checkpoints as we progress to get people in a room together for a mediation. So somebody might call us up and right from the start, they're not prepared to negotiate. They don't want to talk to the other person, so it's unsuitable. Or it might be that they are willing to talk to the other person, but they're a bit apprehensive. So with their encouragement, we write a letter to the other person. We call them party B. So then we invite that person to contact us and we speak to them separately and confidentially about the issue because we don't act for either side. Now, it might well be that, again, we find out that while the first person was willing to talk, the second person isn't. Or it might be that they're both willing to talk and, in fact, they've got some solutions and we help negotiate an outcome before we even organise a meeting or a mediation. Other times, there's a lot of issues that need to be talked about. They need the assistance of a third person, so we'll proceed with the mediation. Now, if the mediation doesn't end in an agreement, most of them do, but some don't, the parties still have other options in relation to the legal system. So the mediation doesn't happen in a vacuum. When we talk about assessment of suitability, there's a number of things that we're looking for. We're talking about risk factors as to whether it's even suitable for people to come together and meet in a room. Is there a risk of violence? We also subscribe to a code of ethics where we want to make sure that the mediation process does more good than harm. So we need to make sure that there is something that needs to be talked about. There is space for negotiation. We need to make sure the timing's right so that both parties, both people are coming to the mediation process are ready and willing to talk. And we need to make sure they also come prepared. So if we are talking about a fencing dispute where one person wants to replace a dividing fence and the other person doesn't want to go to that expense, have they got quotes? Have they got someone, an expert, to look at the fence? So what information have they looked at the legal steps that they would need to take if the matter doesn't resolve at mediation? So then they can make informed decisions, because that's what mediation is also about, is helping both sides make the best decision. Now, think about a matter, a concern, a complaint that you might have. If you have a complaint about something that happened at school and you take that to one of the counsellors, one of the things that you hope you would get, and if you want to get an effective resolution, you want acknowledgement of your needs and concerns. You want somebody to say, yes, you've had a bad experience. We appreciate that. You want to feel that that person has your interest and you and they have some common interests. So in a neighbourhood dispute, people live in the same neighbourhood. They have a common interest in wanting to get along with everybody else who lives near them. They want to feel safe in their community. When you speak to somebody about your concerns, you want your concerns to be respected, not belittled or put down. And then when a solution is found, people prefer to be part of that process. They prefer to have autonomy for their own decisions about what happens. So we keep those 5 factors very much in the forefront of everything we do at the Dispute Settlement Centre of Victoria, particularly if we're getting people to come to mediation. We want to make sure that when both people come in and talk about their concerns, that the other person will acknowledge what's happened. We get them to reflect on why they're there together, what their connection is. We make sure that there are ground rules to ensure that there are discussions of respect, and we make sure that when an agreement is made, that it's the people who've come to the mediation who are included in every part of that process, and it's their ultimate decision to proceed with any agreement that's made. So how does mediation work? If you've seen dramatisation on television, you often see 2 people arguing and a helpless person in the middle going, oh, please, can't we reach an agreement? Mediation doesn't work that way. It often takes 2 to 3 hours, and that might be one session, there might be several sessions. It's structured. So there's a series of steps to build trust. So we don't rush at trying to find an agreement. We actually want both sides to listen to each other and to actually discuss what are the key issues and to talk through those issues before we get them to move forward to look at solutions. It's important that the person who's running this process has the confidence of the parties. So they're keeping the information private, they're treating each side equally, they're neutral and impartial. And also both parties are free to leave at any point. There are set rules around which the people agree to before they start, and they're reiterated at the start of the session, so that the bad experience they've had in previous communication is not repeated. And the whole process relies on negotiation. So there's an assumption that both people want to resolve the conflict, and we build on that. So the first part of the process involves each person, while in the same room together, each person one at a time giving a bit of a history about the situation to the mediators, and then the mediators will turn that into a list of key concerns or an agenda, and then we'll guide them through a discussion on those key points to try and find out where they're actually in dispute. But that's looking at the past. Where did you get here? So if you're going for your driving license and you're sitting in the learner's seat, you know, the first thing the instructor tells you to do is look at the mirrors, look behind you. Then you look to the present, you look out the front and you see what the road is like ahead. So that's where in the mediation process, after we talk about the past, we then sit down with each of them separately and we get them to reflect on where the conflict has got them, what their future options are, and what might be better alternatives. Finally, we focus on the future. So we get them to start thinking about what solutions might be, and then we get together and we start to work through those solutions about what's actually workable, achievable, what they both would feel comfortable with. And then we work to a specific wording for an agreement. So why would people want to mediate? Why would people take the option of going through our service rather than going through the court process? Well, it's certainly cheaper. In our case, the service is free, but even if you go through a commercial mediator, their rates for a session versus a hearing that might go for 3 or 4 days is a lot cheaper. And it's simpler as well. We're not bogged down in the rules of evidence because what we're getting to is people's needs and concerns. And it delivers better outcomes because when a matter is taken to a civil court process, the judges can only make a decision on the questions being asked of them. But in mediation, you have flexibility of looking at ways to resolve a dispute. So it can improve relationships. 85% of mediations that come to us, the ones where people have voluntarily referred, end up in agreement. And we also survey people afterwards, and we have a high satisfaction rate, even for people who've not reached agreement, because sometimes at least they felt acknowledged and concerned, even if they didn't reach a solution. The key selling points is that there are no fees, there are no forms, and there are no fuss, because we're the ones who contact the other side. You don't have to contact them directly. We just need their details. There's also no guarantee, but that doesn't start with it, so I don't put that in there. Our service is also confidential, as in it's protected under the Evidence Act miscellaneous provisions. We will provide interpreters whenever required. Now, I say that the service is empowering, and that's not just a nod to some kind of value. The people who come to mediation need to be empowered to reach a decision, because at the end of the day, we don't enforce the agreement, they do. So they need to have gone through the process and seen the sense in the agreement that they're reaching. And because they've invested the effort in reaching the agreement, invariably they will make the effort to see the agreement through. So finally, I'll put our contact details here. Currently, because of the pandemic, we're not using our phone line service. We're asking people to contact us through our website. And there are certain restrictions because we're working through assisting other parts of justice, working through some lists. So we have got some restrictions on our service at the moment. But that information is available on the website. So thank you for your attention. I hope that you've learned a little bit more about mediation and ADR, and that if you need a service like ours, you know where to find us and what we'll do.